I'm also unaware of the application, my lord. And as I've indicated this morning, my lord, and I took it up informally with some of the people that does the filming, my lord. As I've indicated to them that, my lord, I have no objection if they do filming, my lord. However, I do not want my face to appear on TV. The reason for that is the risk, my lord, is that there's a safety factor, because I do frequent the public with my little children, my lord, without any bodyguards.
Yes, but I think we first need to ascertain, is there somebody from the press, or is there a counsel or a lawyer in court who is making application to do this? Because it's not done without a proper application or motivation. So there is no response. So what I'm trying to ascertain is, there's a protocol to be followed. The court does not just allow the press to come in with cameras and TVs and there's a protocol to be followed, also for the security of role players, witnesses. So is there no application, or is there no formal application or informal application to form these proceedings?
If there's somebody to address the court.
So usually the NPA would send us...
Sorry, can you remove your mask? I can't hear you.
Sorry, sir. Usually the NPA would ask that we send them something, an application, so we can fill in the court. But this time, no communication to that regard was made. So I think all of us then assumed the protocol remained with the other court cases.
What was the previous protocol?
That we send an application to come and fill in or record.
Yes.
And then the NPA would then bring that application and then would be approved.
So are you saying that this was done before, in
was
this matter?
Not for trial, for the previous court hearings. So when the matter was heard, I think last week, 2 weeks ago, last week we were in court, but not with you, sir.
Yes, this is the first time this is on my roll. Well, let me first ascertain from counsel what their attitude is before any filming can take place or recording. Yes. Mr. Mohammed, you indicated that you don't have a problem.
Yes, my lord, just
as long as
they don't film myself. Yes, they can. I have no problem if they record my voice, mention my name. Only objection that I have is me being filmed and appearing on TV, my lord. So what please?
Mr. Makubela.
As it may please the court, my lord, Mr. Mukosho, instructing attorney, is present here with me, and we both confirm that we do not have any problem with the whole proceedings being recorded and or publicized. In any event, our client's face has been all over the social media, the media, and so forth. So the horse would have bolted anyway. As me, please.
And you don't have any objection.
Not at
then,
all.
Or you're instructing attorney to your faces being
Not at all.
filmed.
Not at all.
Yes.
But I just approach.
Yes, sure.
Thanks.
Yes, thank you. Yes, well, let me then issue a directive to all the members of the press. You are welcome then to film, televise, record these proceedings subject to the following conditions.
Uthi uyaniqwayisa ke mina the press ukuthi ke niyamnikelela ukuthi ningaqhubeka nomsebenzi wenu nithole nirekhode ngaphansi kwaleli kodi.
That the face of the state advocate may not be filmed or televised or shown in any manner.
Ukuthi ningavezi ke ubuso bakhe emshushisi kule nkundla noma ngayiphi indlela.
You can record his voice.
Kodwa ke ivoice yakhe ningayirekhoda.
You can mention his name.
Ningabiza legama lakhe uma nithanda.
But no filming whatsoever is to, no filming, televising, publishing of his face is to be done.
Ningavezi ubuso bakhe njengoba esefake isicelo. Kuyazwakala?
Is that understood?
Understood, my lord.
Yes. And then simply for the purposes of the record, Mr. Makubela and Mr. Mohammed did see me in chambers prior to the court resuming. Mr. Makubela indicated that having regard to the fact that this court was engaged in a full court appeal in Palm Ridge, he believed that he would take the opportunity to attend to other business elsewhere. In short, the court accepts his and his instructing attorney's apology for their absence when the matter was called.
President, please, the court.
As a court, please.
Ubesephawulile-ke ummeli kanye nomshushisi baya ngasese bakhulumisana ke nenkundla bathi-ke bavumelene-ke kanti futhi uyamukela nencazelo yabo ukuthi isizathu sokuthi bangabi khona ngaphambilini esikhathini esidlule ukuthi-ke ubone ukuthi naye inkundla ayikho wabona ukuthi naye ase agijime-ke avale kwezinye ikhala la angavala khona manje uthe uyayamukela-ke ukuqolisa kwabo ummeli. Kuyazwakala?
Thank you, Mr. Mohammed.
As a court, please. I believe my learned friend would like to address the court now regarding the progress of the trial, my lord. As a court, please.
Thank you, Mr. Makubela.
As it may please the court, as of last week, when it became apparent that for purposes of starting with the trial in defense of the accused, the defense preparations to an effective discharge of the mandate had been inhibited, amongst others, by arrangement with the prison authorities for a consultation.
Uyaphawula-ke ummeli ukuthi-ke kusukela kuleli viki elidlule-ke ukuthi kuyenzwa amalungiselelo ukuthi icala leli lisuswe-ke licala likhulunywe-ke kuye kwaba nezihibe ezithize-ke lokho kuvela ngasecaleni lamaphoyisa ngale lavalelwe khona ummangalelwa.
And this had been against the background of various telephonic attempts by my instructing attorney to make suitable arrangement for a fruitful consultation.
Uthi kuwukuthi-ke ummeli lo ohleli eceleni kwakhe-ke ubeyenze imizamo eminingi ngocingo-ke ezama ukuxhumana nabo laba baseprizini ukuthi-ke bazame ukuthi babanikeze ithuba-ke lokuthi baxoxisane-ke nalo muntu abamele kuyena ummangalelwa.
We then took it upon ourselves to make contact with the state, my learned friend for the state,
uthi yena-ke wabesethatha amanyathelo ukuthi axhumane-ke nomshushisi uqobo lwakhe
and advise them of our situation.
nokuthi abazise imeko abakuyo ngaleso sikhathi.
It then became apparent then also from them that there appears to already have been a court order to the effect that there is a preferred matter ahead of us, the existence of which affected the possibility that we would in any event have started with the child, even if we wanted to, ready or not ready.
Uthi kwase kuyacaca-ke ukuthi kukhona kanti elinye icala ebelingaphambi kwaleli okumele kube yilona elidikidwayo, okusho ukuthi-ke nalo belizothikamezisa-ke ukuthi icala leli licale noma ngabe besekulungile ukuthi singaqhubekela phambili noma cha.
Our understanding was that we would rather have had the matter today rolled over for about a week to start somewhere next week, Monday also, if at all possible. But we indicated to my learned friend and the role planner that having had 7 days allocated for us, if 5 days thereof is consumed, there is no way that we could do anything of significance in the 2 days that was left. And in any event, our availability thereafter was also making it impossible for us to can run with the matter beyond the 7 days that was allocated.
Uyaphawula futhi uma ngabe behlelwe ukuthi icala likhulunywe kulamalanga awu-7 esibekelwe wona, uma ngabe lanka amalanga amahlanu asemoshekile-ke akusakusizi ngalutho ukuthi siqhubeke kulanka amabili-ke ukuthi siqhubekele phambili.
Yes, if I can just interrupt you there. Mr. Mohammed, which matter was the preferent matter?
Yes. It's the matter of Mr. Ngodwana, my lord, the one that was rolled over to next week Tuesday.
Yeah, the two matters appears. There's the Makwena matter and others, and the Undo and others.
My lord, I can't.
The one has 8 accused and the one has 3 accused.
My lord, I can't recall, but it's one of those matters, my lord. But both of them were rolled to next week Tuesday. But if I recall him correctly, my lord, that whilst he was addressing this court, is the one where the Honorable Justice Ismail Mohammed has indicated, my lord, that the matter must proceed today.
Yes, yes.
It's that matter.
That is the one where the council withdrew from the matter.
Correct, my lord. Yes. And just to elaborate on that aspect,
the
my
one
lord.
with the 3 accused.
Yes.
The-
Because
that's the Makwena matter.
I see this Honorable Court's registrar is nodding her head, so I presume, my lord, it's correct, my lord. My lord, and I did inform.
No, I don't need, don't presume that because my registrar is nodding her head that I'm correct.
As a court pleases, my lord.
Because I have my notes here of what transpired this morning.
As a court pleases, my lord. My lord,
Mr. Creel appeared for these accused
Yes.
and withdrew.
my learned friend is referring to that matter, my lord.
Yes. Yes. So, yes. Very well. And you say then that of the 7 days estimate, you would only have 2.
We would have only had 2 on which we would have at least,
Yes,
but
yeah,
that
the
2,
court in any event has got its new role next week.
yes, with respect.
Yes. If I may just inquire, what is the difficulty with your attempts to consult at the prison?
The difficulties are presented by the difficulties that everyone infected or affected by COVID-19.
Yes.
The consultation environment is such that it does injustice to privacy, and also, if I were to give my lord an example, that we will use an intercom to communicate with the client, And around us, there are other people that are still consulting. Sometimes the intercom goes dead, and then we have to jump from one cubicle to another. And there are documents that we need to share with our client, and which is also a critical aspect of which I will address the court more regarding our application to substantiate the postponement. The state's case.
Isn't it possible using those facilities to handle documents?
No, it's just impossible.
You can't do that.
You can't do that. You have to plug it on the glass, and then there are things that need to be pointed out, and
The court is
the
familiar
yeah.
with the consultation rooms at the prison.
Yeah, no. Instead of the usual open consultation room.
Open consultation where you can sit next to your client
Yeah.
and consult properly. Yes.
And then 2 consultations were only limited to Fridays
Yes.
for a very long time. And it's only recently with the new announcement by the president that it has been raised to 2 days. But we're also waiting to hear whether that 2 days increase also include an open consultation, or we're still going to use that inconvenient and unreliable means of a consultation. And more than that, the state's case is largely based on very, very technical evidence, to use for lack of a better way. We have engaged our experts in this regard, and because of the competition between the state and the type of experts that are required for this type of expertise, we had a difficulty in getting one that has not been exposed, or at least would be conflicted with having to assist us, because they're also assisting the state in other matters and so forth. But fortunately, we've had a feedback where we have one that we still have to consult with, and also consult with the accused, as well as the evidence that there is. So basically, even if we had today to start with, we would not have been able to do so because of the overall difficulties that I presented to your lordship.
Usephaulile ke umeli ukuthi kunenkinga nezihibe nezihiga manje ezavimba ukuthi lecala liqhubeke ngendlela efanele, uthi phakathi kwaloko kudalwe yilesi sifo esingenile se-COVID-19, kwadala ukuthi ke imigomo ebekiwe ke ngaphansi kwaleso sifo se-COVID-19 kube nzima-ke ukuthi abameli bakhulumisane nabantu ababameleyo kuyibona abamangalelwa, ngoba kukhona indlela okumele kwenziwe ngazo, uthi lezo indlela lezo zithikamezisa umsebenzi wabo, ngoba bakwazi ukuthi baqhubeke ngendlela efanele, balungiselele ukuthi icala lizokwazi ukuqhubeka phambi kwenkundla.
And the long and short of it is that we are, with respect, seeking indulgence for a postponement in order to assist in preparations and also mounting a defense for the accused based on the consultation that we have had.
Thank you.
Thank you, Madam.
Mr. Mohammed, it is so, isn't it? It appears that the current matter before the court is a 2020 matter.
Indeed, my lord. It's the first time that it's been set down for trial. Is so.
It's the first time.
Yes. The offense was committed last year, June, around about June, my lord.
We were dealing with matters this morning that date back to 2016.
Correct, my lord.
And accordingly, those would have been the red matters
Yes.
on the roll.
Indeed, my lord.
This is not a red matter.
Not at all,
It
my
may have public interest, it may be a high-profile matter, but it's not, legally speaking, a red matter.
Correct, my lord.
And what is the state's attitude to the application by the defense?
My lord, the state is not going to oppose my learned friend's application for the following reasons. First and foremost, I need to accentuate the following, my lord, that the state is ready to proceed. If this honorable court, hypothetically speaking, were to order that we were to proceed during this week, we would have been ready to proceed, my lord. However, my lord, there was another factor when my learned friend also intimated to me that he intends bringing this application, and a weighty factor which I've considered was as to whether the state is going to be prejudiced in these circumstances. And the conclusion which I reach, my lord, is that the state is not going to be prejudiced for the following reasons. Our star witness is currently serving a custodial sentence of 20 years, my lord. So he's safe and we can reach him easily, my lord. He's not going anywhere. It is also so that the state will be relying a lot on the cell phone, cellular data, my lord, and the available witnesses, or rather experts that can come and explain this to this honorable court as to the workings thereof. There's more than one available working for the different cell phone providers. If one is not available, the state can always obtain another expert who's also working there to come and explain the said cellular data, my lord. So at this stage, my lord, the state is not being prejudiced, my lord. However, I would urge my learned friend, my lord, that in fact I need to intimate the following: that the state is not, if there is such applications in the near future, my lord, the state is going to oppose it, but not at this stage, because it would be unreasonable, my lord. As a court, please.
uyaphawula-ke umshushisi ukuthi yena akasiphilise isicelo esifakwe nguhulumeni phambi kwenkundla uthi isizathu saloko ukuthi-ke akuhlukumezeki muntu uma singachubeki namhlanje ukuthi kodwa-ke uma ngabe bekuthiwe siyachubeka namhlanje nibeselungele ukuthi sichubeke noma ngabe namhlanje kodwa-ke akasiphikisi leso sicelo aphinde aphawule futhi-ke ukuthi-ke esikhathini esizayo kodwa-ke uma ngabe umele uzofaka isicelo esifana nalesi uzosiphikisa ngaleso sikhathi okwamanje uthi cha inkinga yikho ngoba naye lofakazi abathembele kuye luvalelweni la ayenza khona iminyaka engu-20 eluvalelweni so bathi inkinga yikho lapho singakwazi ukuthi luhlehliswe necala.
I have no further reasons to put on record unless there's something that this honorable court would like me to address this honorable court on.
No, thank you very much.
As a court, please.
Anything you have promised, Mr.
Nothing further, my lord. Thank you.
Is the accused is in custody?
He is indeed in custody.
And what date are we looking at?
We are guided by the role planner and the date that is given us. Which we put.
My lord, as a court, please, I will address this honorable court on that aspect. The first open date which is suitable to Mr. Makubela is the first day of the next term, which is the 17th of January. But again, my lord, for the record, the state were in a position to proceed during this term rather. However, Mr. Makubela is not available after this week.
Is our expert available for the term?
Scott, please. So the first available date, which is suitable to the defense, my lord, is 17 January 2022, my lord. My lord, my learned friend has informed me, asked me as to how many days it is. I've set it down, or anticipate that to present the state's case would take about a week. However, my lord, it is, in a high court, we are running a running roll, my lord. So I would request my learned friend to at least avail himself for 3 weeks, my lord. So that if we start on the 17th January, which I think will definitely will, my lord, so that we can run and finish the matter. Because the family of the deceased also in this matter, my lord, they also want closure in this matter.
Please, please.
As a copy.
Mr. Makubela, what do you say about the state's request?
Yeah, the 17th is suitable.
Yes, and will you keep yourself available for 3 weeks?
For 10 days, yes.
15 days is 3 weeks.
We will make
Bearing in mind that the court is well aware that in these matters, the state's estimates are extremely conservative, and invariably the matters roll over.
My instructing attorney confirms, and I also confirm.
Yes. Yes, very well. Having regard to the following factors, namely the difficulties that the defense has encountered in these COVID times of properly consulting with the client.
Uthi ngenxa yokuthi-ke kuye kwaba nenkinga yokuthi ummeli akwazi ukukhulumisana-ke nommangalelwa ngalesi sikhathi se-COVID-19.
The fact that this is the first time this matter has been set down for trial,
Nokuthi-ke liyaqala leli cala ukuthi libekwe phansi ukuthi lizokhulunywa.
it is not, whilst it is desirable that matters proceed, this is not a red matter in the sense that it is a 2020 matter.
Noma sithanda-ke ukuthi amacala asheshe aqhubekele phambili akhulunywe, kodwa-ke leli alikabi icala elibi kangako ngoba icala lango-2020.
The fact that counsel for the defense would not be available from next week, and nor would his experts be available this term.
Nokuthi-ke ummeli angeke akwazi ukuba khona kuleli viki elizayo, nokuthi-ke lo fakazi ababhekane naye okuyena ozinikeza ubufakazi obugcwele kuleli cala, naye-ke uzobe ungakwazi ukuthi abe khona phambi kwenkundla.
The fact that counsel for the state does not oppose the application for postponement.
Nokuthi umshushisi akaphikisani nokuthi leli cala lihlehliswe.
The fact that counsel for the state informed the court that the state will not be prejudiced by the postponement.
Uphawule kanti umshushisi ukuthi-ke naye kuzobe engahlukumezeki uma leli cala lingaqhubeki.
And the fact that the defense properly were under the misapprehension that there would be another red case or preferential case commencing today, which unfortunately could not proceed, having regard to the counsel in that matter suddenly withdrawing.
Nokuthi-ke ummeli lo ubecabanga ukuthi kunecala elaliza ngaphambi kwaleli lapho kumele liqhubekeke namhlanje, kodwa-ke neshwa lelo cala lisaqhubekana ngoba ummeli wakulelo cala uye wahlehla namhlanje.
For all of the aforesaid reasons, and in particular, the fact that were the court to order the defense to proceed, it would impact on the rights of the accused to have conducted proper consultations with his legal team.
Uthi ngazo zonke lezo zizathu ikakhulukazi nasibheka ukuthi uma ngabe inkundla ibiphoqelele ukuthi namhlanje siqhubeke ngaleli cala, lokho bekuzoba kuhlukumeza amalungelo akho oluntu namalungelo esiboshwa.
The court understands that the family of the victim in this matter requires closure.
Inkundla futhi yazwisisa-ke ukuthi-ke ihlobo zaloyo oyisisulu ovelelwe uyena inhlekelele kuleli cala nabo badinga ukuthi sifike emaphethelweni aleli cala.
But those rights or those desires are part of a process of justice.
Kodwa konke lokho kuhambisana-ke nenkambiso yobulungiswa.
And there also needs to be justice insofar as the accused is concerned, who is innocent until proven guilty in our judicial system.
Nawe kumele ubhekelwe-ke nendlela yobulungiswa-ke ngoba kuya ngokomthetho ubona ungenalo icala ngaphambi kokuthi uthole olicala.
And in short then, and having regard to the fact that this application for postponement is not opposed, this matter then is postponed to the first available date to the defence, being the 17th of January 2021. Sorry, let me rephrase that. The 17th of January 2022.
Ukuthi ngaleso sizathu ke okanye isizathu azibekile icala lizawuhlehliselwa i-17 zakaJanuwari kulo nyaka ozayo.
This date, counsel for the defence as well as its instructing attorney have informed the court that this date is suitable and that they will hold themselves available for a period of 3 weeks, in other words 15 court days, for the conclusion of this trial.
Bavumelene-ke abameli bakho-ke kanye nomshushisi ukuthi-ke icala ke bazobe bekhona liqhubeka kusukela ngalelo langa leyi-17 zakaJanuwari kuze kube amaviki amathathu siqhuba ngaleli cala.
And the accused obviously will remain in custody.
So bala-ke ukuthi wena uzogcina elivalelweni ukufikela ngaleso sikhathi.
As it may please the
As a court pleases, my lord. My lord, that concludes our role. Maybe then adjourn, my lord.
Thank you. Thank you to counsel. The court will then adjourn.
Violent